2 o'clock workshop. Supervisor Chadwick, will you lead us in Pledge of Allegiance?
Yes, please join us. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Also, given that it is the anniversary of 9/11, we just take a little moment of silence in remembering of that tragic event. Okay, thank you. As we noted earlier, we're going to have a workshop on Sequa and receive some training. So we have a joint meeting going on. It looks a little different. Up here we have Supervisor Brown and his commissioner, Richard Ward, that's right. Diane Stewart, who is the commissioner for Supervisor Chadwick. It sounds like we have this battle of bands coming on. 2 other supervisors weren't able to join us today, nor a few other commissioners. So we will just do this in a very informal workshop format. Questions from the public we will take after the presentation is done. Presentation is going to be conducted by our consultants from Ascent. So with that, I will, where's Kim? There she is. I will turn the floor over to our planning director, Kim Hunter, and she will set the stage.
Good afternoon, commissioners, board members, fellow staff members, and the public. Thank you for coming out today. Yes, this is a workshop today on the California Environmental Quality Act. It is a workshop and I feel very important training. CEQA is a very complex set of state laws and really dominate the actions that we take in land use in the state of California. So I'm just going to give a brief introduction of what we're doing today, and then I'll be handing it off to Derek Cole for the next step. The objectives today, again, a comprehensive overview of CEQA, and that is defining, explaining, identifying, and demystifying the process. As I mentioned, it's very complex, and so just trying to break it down into something that's understandable, especially as we head into the final cannabis cultivation EIR period, also to touch on EIRs. However, this presentation is not linked to a certain project. It is just a training and overview, just a timely matter regarding the upcoming EIR. Today's presenters are Gary Jacobs, Pat Angel, and Derek Cole. Here's our very simple agenda today. Introductions and some opening remarks, the CEQA presentation, the bulk of our workshop today. And then Derek will give us a brief overview of Trinity County Code Title 18, and then we'll have some questions and comments. So, as Judy mentioned, Chair Morris mentioned, there will be comments and questions at the end. And I do want to be just very much clarify, this is not about the cannabis cultivation EIR work itself. This is a workshop about CEQA and training. There will be opportunities coming up to comment on the EIR. And those opportunities will be Thursday, September 26th. That will be a Planning Commission meeting in Hayfork. And then Tuesday, October 1st, Board of Supervisors meeting in Weaverville. And those are the opportunities to come, give your comments, ask questions on the cannabis cultivation EIR. And with that, I will hand it over to Derek Cole.
You guys can see, okay.
Turn the lights off when the lawyer stands up.
That's right.
Madam Chair, members of the board, and members of the Planning Commission, again, an introduction. I know the board members very well. My name is Derek Cole. I am an attorney in the Sacramento area. I specialize in municipal and environmental law. So for those I haven't met, I have been assisting the county on some of the CEQA issues associated with the cannabis ordinance. And as our planning director has said, we're not here to talk about that, but I mention that only to give you some foundation. I had the pleasure of serving as the county council prior to Margaret, and so it's always nice to be up in this county. I really enjoy it here, and it's a real honor to work here. I do not have really any comments of my own other than to say, in general, Sequa is probably sort of the flagship of California environmental law. This is a state that is very aggressive in some respects about protecting the environment, and that has been the policy for, we're going on nearly half a century now. We're going all the way back to the 70s before I was born. So just to date myself and hopefully not to date others. But CEQA is a very, very important statute, and it is a very big part of what agencies do when they consider any type of project that has any potential to impact the environment. We are fortunate today to have two very distinguished members of the Ascent firm, the consulting firm. I have worked with this firm even before working with them in this county, and I will tell you that the work they do is outstanding, and that the two gentlemen you will hear from today have a fantastic reputation in the state for the type of work they do and for their knowledge of CEQA. So with that, I would like to turn it over to Gary Jacobs and Pat Angel to provide the bulk of today's presentation.
Thank you.
Good afternoon, and thanks for inviting us to be here today. It's good to speak in front of everybody. I'm Gary Jacobs, and I'm with Ascent, and Kim said that we were going to be demystifying CEQA today. So this is it. This is CEQA, and I'm done. Not really. The reality is it's a challenge to so-called demystify it. Among the things that I do, I'm the, in addition to being a principal and one of the founders of Ascent, I'm the curriculum director for the Association of Environmental Professionals, and I've been doing this for about 15 years. And we do all-day workshops once a year throughout the state, and we just train on CEQA and its nuances and differences and things that come up, questions people have, changes in the law and in the guidelines, and legal issues that come up. So it's not an easy law. I will say one thing, and this is the only comment I'm going to make on comments that we've received on the EIR. CEQA, by its very nature, talks about the negative. It talks about the environmental impacts of projects. It doesn't talk about benefits. Its focus is on what a project can do to the environment and how to fix that issue. So it's just by its nature it comes at things from a negative point of view. So we're going to talk about CEQA. We're going to talk about its origins a little bit. But we're really going to be talking about process. We're going to be talking about how to look at environmental documents and how to use them once you approve them to evaluate projects that you see coming forward after that. Please, as Pat and I do our presentation, please feel free to interrupt, ask questions. We're here for you. We're here to try to demystify as it is. We go to the next slide. All right, so I'm going to talk about the background, and if you can go one more. So now I was around when CEQA was passed, and I started practicing 10 years after it was passed. In 1969, there was a major oil spill in Santa Barbara. We had rivers burning. I grew up in Southern California. There were days where you couldn't breathe because the air was so polluted. And in that kind of atmosphere, the country was hungry for a way to tackle environmental issues. So on the national level, the National Environmental Policy Act was passed and signed into law by Richard Nixon. And in 1970, the California Environmental Quality Act was passed and signed into law by Ronald Reagan. A little bit surprising when you think these are conservative people, but they passed these groundbreaking, or signed at least, these groundbreaking environmental laws. The principle, the foremost principle of CEQA, the cornerstone of it, is that it is intended to be interpreted in a manner to afford the fullest possible protection to the environment within the scope of the statute, CEQA. It's litigated all the time, and what that means gets defined and redefined all the time. Next slide. If you look at the top objectives of CEQA, so CEQA's got a preamble, just like the Constitution does. It's not quite as eloquent, but it talks about CEQA as being a process. It's not a permit. So an environmental document, when you approve an environmental document, it does not approve a project. It doesn't approve you to do anything. It just is your statement that that environmental impact analysis, whether it's an environmental impact report or another document, adequately evaluates the impacts of a project. Its intent is to disclose and focus on the significant effect of project activities, identify ways to avoid or reduce environmental damage. This is perhaps the most important thing that an environmental analysis does, is it looks at the possibility of an environmental impact, and then it comes up with ways to try to avoid it. Requires implementation of feasible alternatives or mitigation measures. What does the word feasible mean? I want to talk about that for just a moment, because this is really important in your deliberations of environmental documents when you see them and in how these are considered. An environmental analysis will come up with alternatives. An environmental impact report is required to address alternatives. We're going to be talking about the different environmental documents. Mostly we're going to be talking about environmental impact reports today. But they're required to come up with alternatives under the statute, EIRs are, and mitigation measures. They're required to be feasible, at least potentially feasible. But the ultimate decision on whether or not an alternative is feasible or a mitigation measure that reduces an environmental impact is feasible is the decision maker. And what do they have to weigh? They have to weigh whether or not that mitigation measure or that alternative is economically feasible, socially feasible, technologically, legally. So there's all these different factors that come into play in determining feasibility. An environmental document may come to you with proposed mitigation measures or proposed alternatives that reduce impacts, and you may say, these are infeasible for the following reasons, and we're going to accept them. So these are things that can happen. An objective is to disclose to the public the reasons for agency approval of projects, even with significant effects. So here I said you can actually have you can prepare an environmental impact report for a project and have significant and unavoidable impacts, and you can still approve a project. It's a way for you to explain why you're going to do that to the public. So it requires this kind of disclosure, but that's what environmental documents do. Other things, foster interagency coordination and review of projects. You see, for instance, Caltrans will often comment on an environmental document. They want to see X, Y, Z. The California Department of Fish and Wildlife wants to see certain protections, so that's also part of the process. And enhanced public participation in the planning process. I sometimes think of, even though it's not a planning document, I still think of the process of consideration and an evaluation of environmental impacts of a project, almost the last bastion of participatory democracy, because everybody has their ability to express in writing what they want, and they often do. And then we respond. CEQA neither approves nor denies a project. That's very important. It just discloses the impacts. You, as the decision-making body, then take that and you decide what you want to do, whether you want to approve it or not. The environmental document is intended to be neutral, notwithstanding the fact that it's a little bit negative, but it is intended to be neutral. So CEQA has certain directives, and I'm going to sound like I'm contradicting myself, but it's really not a contradiction. It requires you to adopt mitigation measures, feasible mitigation measures, or feasible alternatives to reduce the significant environmental impacts of a project. But they have to be feasible. So there's a requirement, but it's got to be feasible. It authorizes you to disapprove a project to avoid significant effects. You can not approve a project because you find that the impacts are just too severe. You can approve a project if there's unavoidable effects and the benefits outweigh those unavoidable effects, so you're allowed to do that. So there are other authorizations that I don't really want to spend too much time on, so we'll move on. So here are just the legal authorities. What is CEQA? You see that it's the same thing here. This is both the guidelines and the statute. Statute is goes to about there, and then the guidelines are the rest. So it's a thick document. Gets added onto all the time. Every year the legislature tries to improve it and usually makes our job more difficult by doing that. But that's the intent. It's guidelines, statute. The statute is passed by the legislature. The guidelines are the interpretation of the statute. Both of them have legal authority. The statute is a legislative tool. The guidelines are prepared under administrative law. But both together have the weight of law in court, just different levels of weighting. There are also court decisions, and our practice is frequently influenced by the decisions of either appellate courts or the California Supreme Court. Anytime there's an appellate court decision that is published, it technically only applies to the appellate district in which it is published, but it generally is, the general practice is that it's statewide because it does set precedent. And then the Supreme Court will often take on cases, especially when there are competing decisions on precedent. One would say one would say the other. They conflict with each other, so sometimes the Supreme Court will be the ultimate decision maker on that. We have to be knowledgeable of these things. We have to make sure that our environmental documents recognize and follow the guidance of the courts to the degree that we possibly can. The Office of Planning and Resources also prepares technical advisories, and these technical advisories are just that. They're advisories. They're sent out to the industry. We use them as information when we prepare our environmental analyses, but they don't carry the force of law. Other things that don't carry the force of law are the appendices to the guidelines and the statute. So there are a series of appendices that are really great documents. They have the notice of preparation form, the notice of determination form. These are important forms that are used in preparing environmental documents. Perhaps the most important appendix is Appendix G. What is that? That is the appendix that includes the environmental checklist. And people often say, you didn't comply with Appendix G. Appendix G is advisory. It's suggestive, but it's not law. So it advises us. People often say, well, that's the threshold. The thresholds of significance are the questions in Appendix G. Will the project be exposed to certain earth movements? Questions like that. The answer might be yes, but they can be mitigated. It might be less than significant, and they're not thresholds of significance. They're just what lead us to what kind of document we need to prepare. So some key terms. The first is a project. A project is a discretionary action, so something that generally is an action by a planning commission or a board of supervisors or a city council that has physical environmental impacts. So it's got to have both. It's got to have physical effects. Doesn't have physical effects, it's not a project under CEQA. There are different terms that are used in the process. The categorical exemption is a specific class of projects that are exempt by virtue of what the project types are. They're so small, they're in a certain location, they're a certain type of project that generally does not cause an environmental impact, but there are exceptions to the exemptions, and they're also listed in the guidelines. An initial study, so I talked about Appendix G. Appendix G is a checklist. It's often what's used for initial studies. It's mostly what's used for initial studies. That's the checklist that's used that people will go through, and they will look at each of these topical areas from air quality to traffic to greenhouse gases and answer a series of questions, and using substantial evidence to support the answers will determine whether or not a project may have a significant effect on the environment. Negative declaration. A negative declaration is a document that is prepared when, after preparing an initial study checklist, you have determined that there are no significant environmental impacts of a project. It doesn't mean that there are no effects, it just means that there are no significant effects, and I'll define significance in a few minutes. Mitigated negative declaration, it's a negative declaration, but there's mitigation measures that are included to reduce the significant effects to a clearly less than significant level. That word clearly is very important. An environmental impact report is, some people call it the heart of CEQA. I don't really call them that, I just call them the most extensive documents. They're the ones that are prepared on larger projects with the potential for significant environmental impacts, particularly environmental impacts after the application of mitigation. There still may be residual environmental impacts. Lead agency. So the lead agency is the agency with the primary approval authority over a project. If somebody comes to you with a project to build a shopping center, for instance, you're the primary approval authority for that, so you're the lead agency. There still may be other agencies, responsible agencies, who have to issue permits. Caltrans might need to issue an encroachment permit. So they would be a responsible agency. They would use the environmental document to help make their decision, but they're not the ones who approve the environmental document in the first instance. And then there's trustee agencies, and I'll explain what those are in just a moment. So I already told you what a lead agency is, but the lead agency is also the first agency that approves the environmental document as adequate. So I've often described to my kids what I do for a living. I tell them what I do is I work really hard. Sometimes people yell at me and say they don't like the work that I do, so that people like you can tell us that we did an adequate job. And I thank you for that. So that's what a lead agency does. Also consults with other agencies. Next slide. Responsible agencies, I described what they were, so let's not spend any time on those. Trustee agencies, they hold the resources of the state of California in trust, so they have broader authority. There's only 4 of them: the California Department of Fish and Wildlife, State Lands Commission, the Department of Parks and Recreation, and the University of California. They just have a broader authority. They can comment on environmental documents that affect the resources that they hold in trust. So State Lands Commission probably doesn't have much of a role in Trinity County unless we're talking about a river, effect on a river or something like that, where they do hold jurisdiction over high water marks, things like that. So key points in the timing of CEQA. So again, this will sound a little contradictory, but first off, CEQA must be completed before a project is approved. Okay, that's good. You got to start as early as feasible in the planning process to help environmental considerations influence the outcome of a project. There's often times when we'll get involved in the design of a project, and we will do environmental analysis and we'll make suggestions to try to change the way that project is designed so that it can avoid environmental impacts. There's other times where the environmental impact report itself will change the project design and project considerations. But start as early as possible, but late enough to provide meaningful information. What does that mean? We have to have a project that we're evaluating, and sometimes projects are in flux. So late enough that at least what we're evaluating is the project or will soon be the project. Has to be, CEQA compliance has to be completed prior to acquisition of a site intended for a defined public project, but there are some exceptions to that, so we don't need to go into that. And no action can be taken that gives impetus or commits to a feasible project in a manner foreclosing alternatives or mitigation measures. You cannot decide on an action associated with a property or with a project that foregoes your ability to make a decision on whether it should be mitigated or an alternative should be selected. And an example of that would be if you commit money to a certain cause of action before you go through your environmental review process. And that cause of action forecloses other abilities. You buy a site, and that means you can't buy another site. So these sorts of things. And let's see, next one, yeah. Kat, you're up. Any questions on this before I turn it over? Okay.
Okay, good afternoon. Again, my name is Pat Angel. Thank you again for the opportunity to speak before you. I'm going to touch on the preliminary review process, and this is really a step as a decision maker. You don't really get to see this is handled at the staff level, but it's still kind of important to understand what CEQA means when it uses the definition of a project and how staff will evaluate that and moving forward to either preparing an environmental document or determining that CEQA is not even applied to this situation. First slide, please. So as I just mentioned, it's usually a pretty informal step that's done. The most common situation is a application comes into, let's say, the planning department for a subdivision, and they will, as part of their completeness determination of the application, they will make a determination on whether or not it's subject to CEQA, is a project under CEQA. They will also, as part of that, is look at, well, maybe the project's actually exempt under CEQA. There are, as Gary mentioned, there are a series of exemptions that are available. So, next slide, please. This is kind of a very simplified streaming of the process that your staff does to determine whether or not CEQA applies and to what extent it may apply. And it basically boils down to some basic questions. The questions are, is it a project as projects are defined under CEQA? Could it have a significant environmental effect? Is it exempt under CEQA? Is it exempt as a statutory action or as a categorical action? I'll explain those in a minute. Was the project previously evaluated in a larger programmatic environmental document? Has it already been looked at before? And then the last step, if you keep going down the order of no, is, okay, we prepare an environmental an initial study checklist to determine whether the action actually could have an impact on the environment. And that will determine whether or not the type of environmental document is necessary. Next slide. So Gary mentioned this already in regards to what a definition of a project is under CEQA. The important thing to keep in mind is the whole of the action. It's the entirety of it, and you're looking at both the direct environmental effects that may happen or the indirect. A good example of this is, let's say you're adopting an update to your general plan. Well, your general plan, in all reality, is nothing more than a bunch of paper. It's not necessarily committing yourselves to build or construct something, but it is establishing a process where you've now established perhaps land use designations or density ranges in which something could happen. So that's an indirect effect of your action on adopting the general plan. Also, the action has to be discretionary. Issuance of a building permit, not subject to CEQA. Next slide. So examples of projects that could constitute a CEQA project. Obviously, a public works project where you're doing a roadway improvement or some sort of drainage improvements or anything that's a capital, a CIP project. If you're providing any sort of grant or funding source to another entity that will construct something, let's say a new library or expansion of this library, that would be subject to CEQA. Or anything where you are issuing any sort of approval, a license, use permit to allow somebody to construct something. That is also a project that falls under CEQA. Next slide. So it's really important when you're looking at a project, and staff will go through this exercise, of making sure you have captured the completeness of the project, that you don't result in this issue that's commonly referred to in CEQA as piecemealing. For example, I'll go back to the subdivision. So let's say an application for a subdivision comes in, and an analysis done on the subdivision, and it's a negative declaration is done saying, oh, there's no significant effects. But to build the subdivision, you need to go get an encouragement permit and do a bunch of improvements on State Route 3. That's part of the project too. So it's important to make sure the completeness and all the aspects of what a project triggers and needs gets covered in the project description. Next slide. So Gary already kind of mentioned this about when CEQA kicks in, but when you have enough detail to evaluate the project, pretty much when you've determined an application is complete by staff, you're ready to start CEQA. There may be some additional pieces of information, some refinement you may need, but you're at a point where you can do that analysis and you can start to determine the environmental document path you're on, or if you even have to prepare an environmental document. Next slide. So sometimes the question is, well, what's a non-project? I'll give you an interesting example. A few years ago, I was the environmental coordinator for the city of Elk Grove, and the city wanted to purchase the building next door to City Hall. It was an existing office building that was being used. So we asked the question, well, is it a discretionary action? Yes, it required council to take action to acquire the building. Is there any environmental effect? No, there wasn't. City wasn't proposing to do anything to the building. They simply wanted to buy the building as a piece of property for the city. The existing leases and uses we're going to maintain. So we're like, okay, it's not a project under CEQA. There are some activities where state law particularly exempts environmental review. There are certain maintenance activities that are exempt under environmental review. Approval of your budget is exempt under environmental review. Reorganization of the county would also be something to be generally exempt under environmental review. Next slide. So exemptions, yes. How can we? Okay, we're a project under CEQA, but are we exempt? Is there something that shortens our path and we can just move along and approve this project? Well, there's two types and categories of exemptions under CEQA. There is statutory exemptions, which are clearly defined under law. And in fact, if you look in the guidelines, you'll see a curious one that's for the, I believe it's the 1984 Olympics in LA.
Yep, yeah, another one of those, you're good.
Yeah, so if we have that one again, it's exempt under CEQA. Clearly, if you're in, and there's some others that are a little more generally defined, that if you fall within that description, you're exempt, no question. There is no subjectivity in regards to whether that is. You file your notice of exemption, 35 days statute of limitation passes, which is the time somebody can challenge you on the exemption determination. If that comes and goes, you're good. Then there's a set of classes, 33 classes known as categorical exemptions, and these are more generally defined activities such as infill development, if it's defined in a certain way and surrounded by pre-existing construction. Modification of an existing building, that's also an exemption. There are some exemptions, categorical exemptions for roadway improvements, pipeline facilities, things like that. Now, the difference is under categorical exemptions, you need to basically go through the process, identify which, and there might be multiple classes that are identified. You cannot, as explained in a couple of case laws, you can't mitigate yourself to an exemption. So if you got a project that almost fits an exemption, but let's say there's a historic building on the site, and you say, well, we're going to require them to mitigate the historical building to not affect the key features. You can't do that. That just pushed you into an environmental review process. Next slide. There's also circumstances associated with unusual circumstances. I said circumstances too many times there, where it may accept you out of an initial of a categorical exemption. And those are there's a series of circumstances and criteria you need to look at. There may be locational issues associated with the project that's normally exempt that may trigger an environmental issue. Is there potential for significant cumulative effects? Is there possibly a significant effect on the environment? It's normally not something that's very benign, but maybe in this particular case there is. Is it along a scenic highway that will take out a key visual resource of the scenic highway? Does it have hazardous waste materials already on the site you have to deal with? Is it a historic building? Those are all items that you need to look at and consider. Next slide. Now, the important thing to realize is just because you have an unusual circumstance on a site does not necessarily mean you can't use an exemption. Staff may still be able to use the categorical exemption, but they have to first identify through evidence on whether or not there is an unusual circumstance on the site. Do any of these conditions exist? If the answer is no, you're done. If the answer is yes, then the next step is, okay, it's a historical building. Okay, what we're doing to said building, could it have a significant effect? That falls into the fair argument standard, which Gary's actually going to talk about a bit more, and I'm not going to get into the heavy lift on it. But if there's an argument that you could have an impact, then the exemption doesn't work. And this will make a little more sense when Gary speaks to the fair argument standard. I don't want to steal his thunder. And Gary, I believe you're up.
And Gary, just if you give me 1 second, for
Yeah.
those who recently arrived, this is a workshop. This body will not be giving any direction, so just want to make sure that will be clear, but you'll have opportunity to ask questions after the presentation.
Okay. So I'm going to slow it down a little bit because I'm going to be talking about some very important concepts under CEQA that really go to the heart of what we're trying to do here, and also some of the decisions on what kind of environmental document is appropriate to prepare. So let's go to the next slide. So what is a significant environmental impact? Here's the definition. It's substantial or potentially substantial. So it doesn't have to be substantial, potentially might occur. Adverse change in any of the physical conditions in the area, and there's a list of what those areas are. A social or economic change by itself shall not be considered a significant effect on the environment. What does this all mean? It means that if you have a big and bad physical effect on the environment, you have a significant effect. What's big and what's bad? What's substantial and what's adverse? It's circumstance driven. So we look at a variety of issues as we're going through our analyses. I'll get to that in a second. The last part, a social or economic change, is not considered an environmental impact. So property values, those are not environmental impacts. Social issues, social disruption, crime, believe it or not. The increase in crime is not an environmental impact under CEQA. Case law says that it's not an environmental impact under CEQA. So CEQA is very focused only on physical environmental impacts, not on good or bad economic and social change that a project may result in. That doesn't mean that these don't have an effect on decision making. They do. You, as decision makers, balance these things. You'll receive other information. You'll receive public testimony that certain things are really good. This is great. A new shopping center, we really need one. We're underserved. New housing, we need that. But you're going to have an effect on an endangered species. Yes, we're going to do our best to mitigate that. But this social issue is very, very important to us. So it's a balancing. But the social and economic issues come in outside of the environmental review process. Okay? Are we okay with this? Move to the next slide. What about a threshold of significance? So I said big and bad. Well, we always try to talk about thresholds of significance, and sometimes they're really clear, and sometimes they're not. So a clear threshold of significance might be that there's a water quality standard above which, if you cause water quality to degrade above these standards, it's a significant environmental impact. Those are the easy ones. But what about levels of groundwater in a well? What's significant there? Well, adverse effects on a neighbor. I mean, we start to get into things that are much more interpretive, a lot softer. Effects on visual resources. We've got to look at visual resources in Sequa. That's one of the things that is really important. What's the threshold of significance? So sometimes they're not really easy to quantify. There's a lot of other issues that are like that. Air quality. We have air quality standards that if you violate, if air districts have certain standards and you go above them, well, it's a significant environmental impact. But there's other issues that, greenhouse gases. Boy, that is a tough issue. Like, what's a significant greenhouse gas effect? So these are some issues that we grapple with. And if we can't come up with a hard and fast threshold of significance, then we have to spend more time explaining exactly what our thinking is so that you know and you can come to that conclusion too, or argue with us about whether or not we use the right threshold. Next slide. What are the typical topics that are addressed? Not the typical, what are all of the topics addressed in environmental analysis? So this is whether you're doing a negative declaration or an environmental impact report. You have to look at all of these issues: aesthetics, agriculture and forests, air quality, biological resources, cultural resources, energy, geology and soils, greenhouse gases and climate change influences, hazards and hazardous materials, hydrology and water quality, land use and planning, mineral resources, noise, population and housing, public services, recreation. And in public services, by the way, what we look at is not just whether or not you're going to affect police or fire service, but whether or not you're going to cause the need to construct something that could cause a significant effect. So it's, again, very much on the physical side of things. Recreation's the same way. Are we going to be damaging, causing so many people to come into an area that a recreational resource might get damaged, might need new recreational resources to handle a population increase? Transportation and traffic, tribal cultural resources, which are a little different than cultural resources, but they're very related. Utility and service systems like water and wastewater systems, wildlife, and growth. So these are the issues that we look at in an environmental impact report. I know it's a very exhaustive list. Next slide. So when we are looking at environmental impacts, what does CEQA really require us to do? It requires us to disclose the information about the effects of a project on the environment. Sounds pretty obvious. It requires us to identify mitigation measures and alternatives to avoid those effects, and requires us to consider the feasibility of those. Again, we can't make all the decisions on whether something is or is not feasible. That's the decisions of you guys, but we are trying to come up with what we consider to be potentially feasible alternatives and generally feasible mitigation measures. CEQA also solicits agency and public input throughout its process. It does not require mitigation for existing environmental damage. So if a project is coming in, there was a case down in San Diego where somebody illegally mined a river, and there were illegal sand and gravel extraction, and it was taken to court as, whoa, what happens, this project is an expansion of that sand and gravel mining operation. They need to go and fix what they damaged to begin with. Now, there might be other laws that require that, but CEQA does not. That's the baseline. Sounds weird? but that is the baseline that we use. It's what all the legal decisions have basically come to terms with. I know that's an important issue. CEQA doesn't advocate for a project under evaluation. We may think it's a terrific project, and we also may think it has a lot of environmental impacts. And hopefully when you're done reviewing any document that we write, you don't know whether we think it's a good or a bad project. We just hope that you know that it does or does not have environmental effects and how they're solved. It doesn't require that you deny a project due to significant environmental effects. So we talked about that earlier. You can override those. And we also talked about economic and social issues. Okay, I'm going to spend a couple of minutes talking about a legal concept, and if I get this wrong, then we've got legal counsel here to help correct me. There is a concept under CEQA that is called the fair argument standard, and this is very important because this is often the difference between preparing an environmental impact report and preparing a negative declaration on an EIR, or a negative declaration on a project. So, do you mind if I ask the audience a question?
Sure.
Anybody here have red-legged frog on their property? No? Anybody here see an endangered species on any properties or flying around?
I saw one on government property not long ago.
Okay, what was the species?
Well, I guess, actually, you know what, it's probably not endangered, so I'm sorry. It was a bald eagle, it's a sensitive species.
Okay, let's just hold on to that for a second. Let's say a bald eagle is, I don't know whether it is or is not an endangered species. So what is a fair argument? A fair argument is an argument that somebody can make an argument that, based on substantial evidence, that an impact may be significant. May be significant, based on substantial evidence. So this is really a low bar. What is substantial evidence? We have, let's go to the next slide and then I'm going to come back to this. Substantial evidence is their facts, reasonable assumptions predicated on facts, expert opinion supported by facts. It's not argument, speculation, unsubstantiated opinion or narrative, unsubstantiated opinion, clearly inaccurate or erroneous information. Boy, do we get a lot of that. Socioeconomic impacts not linked to a significant effect. That's not substantial evidence. So moving back to where we were a second ago. So let's say that we were looking at this property that this gentleman saw the bald eagle on, and we go out there and we say, there's nothing here. We don't see anything. And we say there are no impacts on any sensitive species. And then this gentleman says, well, we think you're wrong. There was a bald eagle. And one might say, well, are you a biologist? And you are? Oh,
yeah.
Okay.
I took a picture too.
And you took a picture. You are ruining my story. That's okay.
Sorry.
Let's say that you weren't a biologist. Let's say that you're just somebody who is a hobbyist. And you happen to, you're a birder. You love birds. And you don't have a degree in biology, but you know what a bald eagle is. And you present that. And you say, yeah, it's a bald eagle. I know it. Here's a picture of it and all that. Well, guess what? That's substantial evidence. That would be considered substantial evidence. Now, if you would have come up and said, I saw an endangered, for lack of a better word, I'm not a biologist, so I'll just mess this up, a red fox on a property. It's endangered, and the biologist didn't find it, but I did. So, well, what did it look like? Well, it had 4 legs, and it was about yay big, like that. Okay. You ever seen one before? Never seen one before. Do you have any other descriptions of it? No? Are you a biologist? No? Probably not substantial evidence. It's probably more a guess, an opinion. So that wouldn't quite count as substantial evidence. Why is this important? When somebody prepares a negative declaration, it is prepared under the fair argument standard. And that means that if somebody can come up with a fair argument that there may be a significant environmental impact, a negative declaration cannot defend that there is not a significant effect. Now, I gave you kind of a fairly easy issue, but what if it's something like aesthetics, visual resources? A neighborhood doesn't like the way something looks. This happens. There's a case where this happened in Sacramento. They didn't like the way a project was going to look, even though it was an infill area. The court said, yeah, well, that's a fair argument based on substantial evidence. We find your negative declaration to be inadequate because there was a fair argument that there would be a significant environmental impact. We require that you prepare an EIR. Now, what if the EIR has the same conclusion, that there is not a significant effect, and it backs it up with the same information? Doesn't affect the form and the function of the view shed, it's consistent visually with the surrounding area, that sort of thing. Well, once you prepare an environmental impact, substantial evidence is the rule of law. If you have substantial evidence to support your conclusion, then a court will look at that as a supportable and valid conclusion. So, it makes negative declarations, the fair argument standard makes negative declarations a somewhat fraught sort of document if there is challenge and if the impacts cannot, and the word is clearly, be mitigated to a less than significant level. You have a wetland on a property, that wetland can be avoided, clearly. There's a buffer around that, and there's mitigation in there that during construction, there'll be hay bales placed around it so that there's no sediment that gets into it. Pretty clear that you're going to avoid that impact. That's good. But there are other issues that are not so clear, where there's interpretation. And so if there is a challenge to something, if you've got vocal opponents and they can find a fair argument, then it does make negative declarations more vulnerable. So I just want to make that point. Next slide. And let's go to the next one. So there are a lot of tools for determining the significance of environmental effects. The initial study checklist that we talked about, where we go through each and every issue and fractions of those issues. So there's sometimes 5 or 6 different sub-questions on whether you have an effect on agriculture, for instance. So that's one place that guides us. Mandatory findings of significance, I'll talk about that in a moment. And then there's a lot of other areas that we look at, including standards and consultation with other agencies. Next slide. So what are mandatory findings of significance? There's actually a section of the Sequa guidelines, section 15065, that has mandatory findings of significance that say that if your project does any of these, you need to prepare an environmental impact report if you can't mitigate them clearly to a less than significant level. And if you look at this list, it's kind of interpretive to a large degree. Substantially degrade environmental quality, I don't really know what that means. Standing here today, I can go out there and say, yeah, that looks bad, but it's usually because there's a variety of issues that got involved. Substantially reduced fish or wildlife habitat, we generally think of that as sensitive fish or wildlife habitat. So there was a lot of issues that we look at. Threatening to eliminate a plant or animal community, and these are listed plants or animals. They are listed as endangered or threatened in some way or fashion. There are variations of what the lists are: threatened, endangered, proposed to be threatened or to be listed as threatened or endangered. There's other nuances, and we try to explain our thinking when we do our environmental documents. Eliminate important examples of major periods of California history or prehistory. Generally, these are resources that are either listed on an historic register or are eligible for listing. So these are the sorts of things that are mandatorily significant. And then there's some other issues that are, again, they're subject to interpretation. My favorite, achieve short-term environmental goals to the detriment of long-term goals. That's really hard to define, but there are other effects that are considered mandatory. And this last bullet point, incorporate the influence of adopted mitigations before considering the mandatory findings, which means you can mitigate out of a mandatory finding of significance, if that makes sense. Okay. So what happens when you have a significant environmental effect? There's a lot of things you can do. You can prepare an environmental impact report. You can use an EIR prepared for an earlier project if it applies equally to your project, and that's happened once in my 35-year career, so let's not talk about that. It just doesn't happen. Use tiering or other Sequa streamlining from a previous EIR to limit the scope of environmental review. That is a fabulous thing to do. We're actually going to spend a few minutes today after the next segment to really talk about tiering, because that's really an important issue under Sequa. I'm not just going to pass that by. Hold on to that for a little bit. Or you could mitigate the significant effects and prepare a mitigated negative declaration, but keep in mind that you must be able to clearly mitigate those effects so everybody agrees that they're mitigated, or reasonably so. Okay. Pat, I think you're right.
Okay, thank you. So we're going to spend some time talking about the various environmental documents that are available. Really much of this focus will be on the EIR process, but it's good to note the negative declaration, mitigated negative declaration process. Next slide. So this is just an overview of the negative declaration and mitigated negative declaration process. The important thing to realize, and this, it's kind of a thread with the fair argument standard that Gary was spending time, when you prepare a negative declaration or a mitigated negative declaration, you're basically saying, we as the agency has determined this project has no impact, or we've put in mitigation measures that will address the impact. Therefore, we're adopting a negative declaration. You've already made your environmental determination before you, or you've proposed your environmental determination before you've taken action on the project. As a very, oh, I'm sorry, you have a question?
Quick question, Supervisor
Yes,
Chad.
thank you. On your timeline on the days,
Sorry, go on this slide.
thank you. It's a limitation, but there's overlap. So it's not 30 plus 30 plus 180.
That is correct. That is correct. Those are, you should look at those as just isolated aspects and not a sequence necessarily.
Limitation on it, that it's not how many days it's going to take, and then you add those days to the next. You can do this interwoven. Or
Correct. For example, the 30 days is tied to the Permit Streamlining Act requires you, after you determine an application to be complete, you have 30 days to determine what your environmental document process is. You can spend 30 days on an initial study, or you can say day one, we know it's a neg deck, or we know it's exempt, or we know it's an EIR. So, and you're right, all this could also be done sequentially. Yeah, were we still here? I think we were still here. Sorry. Lost my place for a minute. Anyways, please interrupt if you have questions. The important thing to realize is that's a very distinct difference from EIRs, and we'll talk about EIRs later. That's why the fair argument standard applies, because in a sense, you've already have a recommended determination without getting any public input. Next slide. As we talked about, again, we have the fair argument standard, which Gary spent a very good amount of time and a very solid explanation of it. If you have a fair argument, you're basically forced into an EIR process. Next slide. So when can we prepare a negative declaration? Well, this is this circumstance where you went through those previous questions I had talked about in preliminary review, and you said, it's a project under CEQA, there's no exemption that fits to it, but there's no impact. We can clearly demonstrate that through the initial study we prepared. There's no impact, there's no need for mitigation. That's when you prepare and go through the negative declaration process. It also can be used, for example, and Gary will talk about this further, about tiering from a previous EIR. Most commonly in a program EIR, let's say you have a program EIR covering your general plan, and you're now moving forward with an element of the general plan. that is exactly like the general plan and its EIR described. This is a circumstance where you could use a neg deck and say, yeah, it's a project that's going to take action, but it was already evaluated, there's no new impact. Next slide. Mitigated negative declarations happen where you do, through your process, identify an impact, but you also identify that there's mitigation that will clearly address and mitigate the significant effect, and that there is evidence to support that. So you are going forward and you're saying that there will not be an impact as long as these mitigation measures get adopted. The important thing to realize on a private application project, the applicant must agree to the mitigation measures. If they do not agree to the mitigation measures, if they want to contest them, you are now in an EIR process. Next slide. So the basic contents of both a mitigated negative declaration and both documents is a description of the project, a good description of where it's located, who the project proponent is. If it's an applicant, obviously. If it's the county, it's just the county. The proposed finding that there's no significant effect, which in reality is usually a couple of paragraphs in size. The bulk of the document is the attached initial study and associated documentation that is your evidence saying why there is no impact. Negative declarations are literally nothing more, in and of themselves, are nothing more than a notice, so to speak. For mitigated negative declarations, the mitigation measures need to be identified in the project description to be clear that in order to be a mitigated negative declaration, these mitigation measures will be adopted should the project be approved. Next slide. Thank you. Oops, I am out of sequence. So, in regards to mitigation measures, they need to address the impacts. They need to be provided as part of the public review period. Depending on the type of document, you may have a 20-day public review period or a 30-day public review period. The difference between that is in a 30-day public review period, it means that a state agency has some responsibility. You may have to get, for example, a stream bed alteration agreement from Cal Fish and Wildlife. That would trigger into a 30-day review because there's a state agency review process. 20-day means it's all local action, so therefore it's a shortened review process. Mitigation measures, again, need to be fully enforceable. It's also important to realize, and we'll talk about this a bit more about mitigation measures, is you can't require a project to mitigate for something that it didn't cause an impact. Mitigation needs to be proportionate to its effect. You can't make it fix a pre-existing issue. It needs to be related to the impact that you are dealing with on the project. Next slide. So some interesting things to be aware of when you're looking at mitigation measures as decision makers. The important aspects are these 5 questions of, well, why do we need the mitigation measure? It should be clear in the environmental document why the need to trigger a mitigation measure is. It should also describe the what, which is exactly what needs to be done. Does a wetland need to be avoided? Does a roadway need to be widened? Does shielding need to be put on the light fixture? It needs to be very clear. It needs to identify who is responsible for making sure the measure gets taken care of. Is it the county? Is it Cal Fish and Wildlife? Is it Caltrans? It should be clear in the measure, or the implementation piece associated with the measure. Where should identify if there's a specific location on the project site where this needs to be addressed, should be clear. And also it should identify when it's going to happen. Is it something that needs to be put in as part of project construction, or is it something about the operation of the project later? Next slide. So, you get a project before you that has one of these 2 documents. There are a series of findings as you as decision makers need to make. And one is that you considered the environmental document, the mitigated negative declaration, under the negative declaration, with any comments received prior to taking any action on the project. The second finding is very important, that if you look to adopt the mitigated negative declaration before approving the project, that on the basis of the whole record, there is no substantial evidence there will be a significant effect on the environment, and that this material represents your independent judgment and analysis. The key words to be aware of is the whole record. What may happen in circumstances, and you may have already had experiences with on other projects, where there is opposition, there is concern about the project. You've gone through the negative declaration process, you've received comments on that document, you have that, and then the night of the hearing, somebody drops a 20-page letter on you. That's part of the record. You need to have considered that before you take action. If you're adopting a mitigated negative declaration, you have to adopt what's known as a mitigation monitoring and reporting program, which clearly identifies how the mitigation measures will be implemented and accomplished and verified. And then, assuming you've approved the project, you will file, staff will file a notice of determination, which starts the 30-day statute of limitations. If somebody has concerns that you failed to handle the process adequately under CEQA, they have 30 days to file litigation once you file the notice of determination. After that point, the EIR is considered valid. Next slide. So now we get into EIRs. So as we mentioned before, EIRs do get triggered if we have a fair argument standard. Once a fair argument standard has been identified, you're moving forward in that circumstance. There are some projects mandated by statute that requires preparation of EIRs. Also, if a project triggers any of the mandatory findings of significance that Gary spoke about at the end of his presentation. Next slide. Now, the one thing I talked about earlier about negative declarations, when you release that for public review, you've already, in a sense, made your environmental determination. EIRs are different. They actually have points of input and response built into the process, which starts out with a notice of preparation, which there's a 30-day review period. There's a scoping meeting that's held where you're asking the public, we're going to prepare an EIR. We really want to hear what environmental issues are important to you. The draft EIR gets released. That's another period of time, 45 days is the common review period, where again, you're soliciting input from the public about, okay, we prepared our draft EIR. What do you think of the analysis? Is it adequate? Is there something we missed? Is there something that should be considered? And then the final EIR gets prepared, and I believe I have some slides covering these items, so I'll just hit on it anyways. The final gets prepared, responds to those comments, and then you move forward to your process and consider the project. That's where EIRs differ. There's this comment, consideration, response, back and forth that happens to solicit information to improve the environmental document to, at the point when it's before you to take an action, that you have the information necessary to make those appropriate determinations. Next slide. So there are a host of EIR types that are available under CEQA. The most common one is the project level EIR, which is simply, again, I'll go back to my subdivision example. You have a subdivision that triggers an EIR. The EIR is designed that deals with the specifics of designing, constructing, and operating the subdivision. It covers it completely. Subsequent and supplemental EIRs are documents that are done after a previous EIR has been approved. I'll go back to my subdivision example. Let's say they come in and they want to change the layout of their subdivision a little bit. You may need to prepare a subsequent environmental document to cover that change. Same thing with an addendum. There are variations on how you would do that depending on how much the project may change. A program EIR is EIR that looks at things at a much broader scale, such as, again, a general plan. General plans are commonly done with program EIRs, where you don't know what's going to happen on a specific piece of property, each circumstance in the county, but programmatically you have a sense of actions that are going to happen, and so the EIR looks at it in that sort of stance. There's also master and focused EIRs, which are a very specified process, which I think maybe happens, what, 5% of the time, Gary? Maybe. Of all EIRs that are prepared in California. And there's some other associated EIRs that aren't terribly relevant for us here. Next slide. So I actually already kind of hit on the notice of preparation, but that's the first process in which the county would do, sending out a notice saying, we're preparing an EIR, we want your input on what the content of that EIR should contain. So it's an introductory piece, there's a scoping meeting involved with that. There is solicitation not only from the public, but from state agencies, because there are experts in Caltrans on traffic. The Regional Water Quality Control Board obviously has water quality expertise that comes in handy, Cal Fish and Wildlife as well. Next slide. So this is what a contents of a draft EIR is intended to contain, and does contain. It may be organized slightly differently than the way this is noted, but these are the key issues that are required to be addressed, which includes a summary of what the impacts are, and contains an impact summary table typically that will summarize the impacts and mitigation measures. There's a description of what the environmental setting that the impact analysis is based on. And then there's a discussion of the impacts of, you've defined what the setting conditions are that the project is looking at. Now you add the project on top of that, and you ask the analysis to determine whether or not the project changed the environment in such a way that you trigger a significant impact, and you need to look at mitigation measures. And subsequently, as Gary talked about before, alternatives, which is a unique analysis to EIRs. You do not do that in negative declarations. You also have to look at cumulative impacts, which is not just the impact of your project, but other actions and activities, both past, present, and future, that may be occurring that are adding to the circumstance. Air quality is a great example of that, where cumulative actions in an air basin, one may not be a big deal, but you get several hundred people burning it the same day, you may have a particulate issue. It also looks at significant irreversible changes. That's, for example, a project is going to commit a certain land use to a certain condition in regards to energy use, or it's going to convert land in a certain way, and you've made a commitment on the environment. Growth-inducing effects, whether or not the project will necessitate population or job growth in your community. And CEQA doesn't say necessarily growth is a bad thing. It just says if that happens, the question is there an environmental effect from that growth inducement? You have to identify any environmental effects that aren't considered significant, and then you identify your resource and your information associated with it. Next slide. So, unique to EIRs, I mentioned alternatives already. In EIRs, you can have situations where there's significant environmental effects that are identified, but they cannot be avoided. In the Sacramento Valley, for example, air quality is a very common one. Ozone precursors is a very difficult issue to deal with. I already mentioned irreversible changes, growth inducement. I guess I already hit this one. Next slide, thank you. Alternatives. The intent of alternatives is to look at different variations of the project that meets the basic objectives of the project, but substantially lessen or avoid the impacts that have been identified for the project. Now, you're intended to look at feasible alternatives, and they're alternatives that basically are trying to accomplish the same thing of the project and are feasible, that could be accomplished. Oftentimes, there's questions about, well, let's consider a whole different project type. Well, CEQA looks at only alternatives associated with what meets the objectives of the project. So let's say, for example, we'll go back to the subdivision and say, you know what would be more lucrative for the county? A casino. Let's put in a casino. That should be an alternative in the EIR. Doesn't meet the project objectives. Would not be an appropriate alternative for the EIR to look at. Next slide. Final EIRs. So your draft EIR comes out, written comments come in. CEQA requires that all written comments on the EIR be responded to in writing and are contained in the final EIR. And those responses look at the comments that are made, and they may suggest edits to the EIR that are appropriate. There may be expert disagreement on technical analysis, and that gets ferreted out in the responses. But that is the content of the response to comments piece. There is no separate review comment period for final EIRs, but they do have to be made available to any commenting agency 10 days prior to final action to certify the EIR, to consider certification of the EIR. Next slide. So sometimes there's some question about concerns of the adequacy of the draft EIR and whether or not you need to start over again, which is commonly referred to as recirculating the EIR. So the CEQA guidelines provide some guidance on, well, when do you look at recirculating the EIR or a portion of an EIR? And so it talks about new significant information that identifies potentially a new significant environmental impact that the EIR did not disclose, or increased severity of an impact the EIR did disclose, unless there's mitigation that could address that impact. If there's alternatives or mitigation measures the EIR could have considered that would have addressed the impact but weren't addressed or weren't considered, that would be a reason. or if the document was just so fundamentally flawed, that could also trigger recirculation. Now, in these circumstances, it may only require a portion of the EIR to be recirculated if these sort of errors are identified, or maybe the entire. It always depends on the circumstances. And sometimes the project changes between draft and final, and that triggers the need to recirculate a portion of the entire EIR. Next slide. So, findings. Very similar to findings on neg decks and mitigated neg decks, except when we're talking about significant effects. You're still asked to identify that the environmental review reflects your independent judgment and analysis. Now, when you get into looking at significant environmental effects, you have three series of findings that can be made. One is that there's mitigation that's been identified in the EIR that's feasible and will mitigate and avoid the impact, and you agree with that determination. That's one possibility. Another one may be that there is mitigation available, but you as the county don't have the authority to implement it, such as, let's say, improvements on a state highway. You do not have the jurisdiction to go out and make improvements on Caltrans right away. Caltrans does. The third one is there are no alternatives or mitigation measures that are feasible that are available to address this impact, so the impact remains significant. As part of this exercise, you are again adopting your mitigation measures in a mitigation monitoring and reporting program that defines that. If there are significant unavoidable impacts you've identified and you wish to approve the project, you can make what's called statement of overriding considerations, where you exercise your judgment and you say, for example, yes, we realize air quality may get a little bit worse, but the economic benefits from this project far outweigh the air quality effect. So therefore, we are going to determine that we are willing to accept these for the social, economic, whatever sort of benefits you may decide are appropriate. And that is documented in the findings. Similar to neg decks and mitigated neg decks, there is a notice of termination that's filed that starts the 30-day statute of limitations for litigation on the EIR. And I think I'm at the end, unless you have any questions on.
All set?
Okay.
No, I don't know that we don't have questions. We might. I just want to make sure that you guys are done.
Just on the roll.
Okay.
Gary, you're up.
Oh,
Sorry. Okay.
We're almost done.
You thought we were done with you, didn't you?
I thought you were done.
You were hoping.
I
We're still
misunderstood
at
you.
war.
I want to clarify something that I may have mucked up a little bit. I talked about your ability to consider the feasibility of mitigation measures. That's only when you prepare an environmental impact report. When you do a negative declaration, the presumption is that all the mitigation measures are feasible. They've already been agreed to by the project proponent, and they will be adopted. So on a negative declaration, you do not have the ability to change a mitigation measure unless you want to recirculate that document, and it has to go out for public review again. But for an environmental impact report, you have the authority to determine feasibility. Okay? Sorry if I
Oh, that's important.
messed that up. Okay, streamlining tools. I love streamlining because our goal is when we prepare an environmental impact report, particularly if you go to the next slide, a program EIR, that we will do that once and you'll never see us again on any project that comes in after that, unless you want us to help find that that document's consistent. So, what is a program EIR? It is Pat talked about it, but it covers broad programs, zoning ordinances, connected actions, big projects. There's a lot of different projects that you can prepare a program EIR for. And why do you do that? What you're trying to do is you're trying to give the agency the ability to make good environmental decisions on broad scale projects and programs, and then to allow for an efficient review of any action that comes in that's connected to that. So program EIRs are my favorite And we'll go through the process of what happens. Let's say you adopt a program EIR. We just finished one for UC Davis for their long-range development plan. This is a plan that looks at adding 2 million square feet of classroom space, 9,000 students, and 2,000 new faculty to the campus. We did one EIR on that. Since that's been completed, we've now looked at, over the following year, we're now on our 12th, finding that the project is within the scope of the program EIR. So what that means is that we prepared this program EIR. It covered the geography and the types of land uses that we thought would be affected, and it had all the environmental programs in place, broad mitigation measures, performance standards, all kinds of things that the lead agency, in that case the regions, can now look at, and they can say, okay, this new class, 100,000 square foot building is within the scope of that program EIR, and the environmental review process is quite simple when it comes to that. Now, there's this concept of peculiarity, and that doesn't refer to me. It refers to the sites. So oftentimes there are broad programs that are adopted. We find this happens with statewide programs a lot, where the state will set out really, really broad programs in place. Ones like the Endangered Species Act was a great example. We worked on their statewide program for the Endangered Species Act. And there's a process in that where you can find that you can take an endangered species, you go through certain steps. But under program EIRs, if there is an impact that is peculiar to a property that was not evaluated at the program level, then you have to do subsequent environmental review, and I'll talk about that in just a moment. But what that means is that program EIRs are great for certain landscape scale projects. A county is about as large as you can get without getting into a lot of complexity. Sometimes the state tries. Sometimes it's just a few thousand acres that are good for a program level analysis, but what you're trying to do is make sure that you're not missing the local circumstances. So program EIRs are good in certain circumstances for a countywide program. General plan's a good example. There's other examples that they apply. So let's say that you've done a program EIR, you certified it as adequate, and it's now in place. And an applicant comes in with a project that is within the geographic area and project type covered in that program EIR. What do? You do an initial study checklist. And you take that checklist, and instead of asking the questions that a checklist typically answers, you change the type of questions to, is this issue covered in the program EIR? If it is, check, you're done. You explain that it is and why. If it's not, then you ask other questions. Does it cause a significant environmental impact? If no, well, then you don't have any issue. If yes, then you have to go to the next step, and we'll talk about what that is. But if the program EIR covers the activities fully, and the mitigation measures address the impacts that would occur on that subsequent project, then the checklist is it. You don't even have to submit it for public review. You can approve the project based on the finding that the project is consistent and is within the scope of the program EIR. It is a wonderful document. Let's go to the next slide. So here are I talked about this. A project's within the scope if the activity is within the same project analyzed in the program EIR. So general plan, it's consistent with the general plan designation. There aren't any impacts peculiar to the specific parcel that you're looking at. There's not all of a sudden wetlands that wasn't addressed at the program EIR level, that sort of thing. and it's within the same geographic area encompassed by the program EIR. Next slide. And I talked about what you do. You do a checklist. In that checklist, you identify also the mitigation measures that are in the program EIR that apply to this specific project. And it's the mitigation monitoring program that you adopted. You pull in those measures. You make sure that the applicant is doing those. But that's the only environmental review process you do. You don't go out for public circulation again. You can if you want, but you're not required to. Next. If you're not within the scope of the program EIR, which means that there are significant impacts peculiar to a project, or the project's a little different, then there are other CEQA actions that you can follow. One is called a subsequent EIR, one is a supplement, and the other is an addendum to the EIR. And let's see. So a subsequent EIR is when there's really a lot of significant effects that weren't addressed at the program EIR level. And so you address several impacts. It's basically kind of a do-over, but you focus out those issues that you didn't address, that you already addressed sufficiently at the program EIR level, and you don't have to address those again. So you just have to look at the new issues. A supplement or supplemental EIR is when there's just one or two issues. An example would be, well, we didn't really cover wetlands in the program EIR, and there's a wetlands on this property, so we're going to do an environmental impact report looking at this wetland issue. Or we might do a negative declaration, but it's a supplement. It can be a supplemental negative declaration too, by the way. An addendum to an EIR, these are fairly common. This is when you approve a project and later on you look at changes to that project and you determine whether or not those changes would result in new significant impacts or substantial increases in the severity of significant impacts that you already identified. So sometimes a project will change. An applicant will come in with a change to a project after it's undergone environmental review, and you will look at whether or not those changes cause new significant effects. You adopt a program yourself, a new ordinance, a general plan. You might have a change in that that's fairly minor or doesn't, or maybe not so minor, but it does not cause new significant effects. And you go through, we prepare the same environmental checklist that we've been talking about before. It was very handy to make sure that we go through every single issue, but we're kind of thorough in what we do. So that's that. Next slide. Okay, so I talked about what a subsequent or supplement to an EIR is and when it's required. So we don't need to spend any time on that. And let's go to the next one. Real quickly, because this really isn't applying to much that you're going to be doing, but a project that's consistent with your general plan, zoning, or a community plan, there's a section of CEQA called the partial exemption. It's nicknamed partial exemption. It's this one section, 15183, that effectively says that you don't have to do anything. You don't have to prepare any environmental analysis if your project is consistent and was covered in the prior EIR, and there are no impacts peculiar to that parcel. It's like a program EIR. So we're giving you a lot of information here. I don't want to spend a lot of time on things that aren't too particular here. One important consideration that we want to talk about is baseline. So go to the next slide, please. Baseline has been one of the most contested issues in CEQA over the last, I'd say, 20 years. The question is, well, what if there is pre-existing damage to properties? What if there are legal activities? How do those apply to environmental analyses? Normally, so the word normally is very important. The environmental setting that is in place at the time that when you do an environmental impact report, at the time the notice of preparation is released, on or about then. That is typically the environmental setting. Or when you commence your environmental analysis, like when you do a negative declaration, that is the baseline for determining whether or not there are environmental impacts. So if there's damaged conditions, those are the baseline. There are exceptions to this. An example I'll use is if you're looking at a hydrologic system. We work on water projects, and so we might look at, like, say, placement of a structure in a river, a dam, something like that. Well, if the notice of preparation was released in the summer and flows were so low that there was barely any water in the river, it wouldn't really be indicative to say that that is the baseline condition. So we might look at the hydrologic record in that instance, because that's logical, because it would be misleading to not include that. And the word misleading becomes very important. The baseline are the conditions at the time that we start our work, unless it would be misleading to show otherwise. Other examples of misleading would be if Highway 299 was in the process of being widened through Weaverville, and a project was going to come in and affect Weaverville 299's two-lane segment through the town, and that widening project was already funded and was under construction. It'd be misleading to just look at 299 as a two-lane segment through the heart of town. I don't know if there's anything like that. I'm just giving you an example. So that'd be misleading. In that case, the baseline would be, well, right now we have 2 lanes, here's the effect, but we're also going to look at 4 lanes because that's a reasonable baseline to look at. So we'll do it in that instance. But if there's instances where there's environmental damage and there's not repair going on, or it's not, broadly known or can't be counted upon, then assuming that that condition would change would not be, it would be misleading to assume that that condition would change unless otherwise informed. So these are some of the things that we look at when we're preparing our environmental documents. And with that, we are done with our presentation, so we're open to questions.
Board members, commissioners, questions?
Yeah, I got a question. I'm curious, does Big Ag in the Central Valley, are they subjected to CEQA?
Is Big Ag subjected to CEQA?
Yeah, in the Central Valley, as far as water use or dust from tilling or spraying and things like that, do they have to undergo that process, or are they exempt?
So if somebody came in with an agricultural operation now in the Central Valley and they were going to convert natural habitat, then they would likely be subject to CEQA. But it really depends on the local agency. So in San Joaquin Valley, for instance, agriculture is generally exempt, and it's exempt by, I believe, by ordinance. In Napa and Sonoma County, agriculture is not exempt. So in those instances, conversion of taking out oak trees and things like that, that's subject to environmental review. That's fairly recent, by the way.
And how does that exemption work with, like, a water supply? How can they be exempt from that kind of process of identifying available water inventory for that area?
So again, you have to look at the baseline conditions. So in the Central Valley, for instance, agriculture has been ongoing for a long time. There's other programs that are coming in place, other very strong regulatory programs, the Surface Groundwater Management Act, for instance, that will change the culture of some of that, but that's outside of CEQA.
And then will there be farms that are grandfathered into pre-existing stuff that won't be subjected to new acts?
Not under SGMA, no. They're all going to be subject to their requirement to reduce their effect on groundwater overdraft. That's my understanding.
I have a question. Is there any time limitations to your CEQA studies? Say, for example, a project is proposed, but funding runs out and the project is readopted, say 10, 20 years down the road? I mean, is there a cap to it?
Right.
Like, I myself, yes.
So the question, is there a cap to the environmental analysis? And the answer is yes and no. So if there's a master EIR, which is a very specific animal, there is a 5-year period under which it has to be renewed, has to be looked at again. If it's a program EIR, there is no specific timeline under which it becomes invalid, except if the environmental conditions change such that the environmental impact report does not now acknowledge a new significant effect that would occur that wasn't evaluated. But then you saw that process for looking at subsequent and supplemental EIRs. So I worked on a project in 1990 that wasn't constructed until 2015 down in downtown San Diego, and they used the EIR.
Supervisor Chandler? Yes, thank you. I would like to understand the effect in a reverse model, and please bear with me while I try to explain the question. So we have environmental damage from previous illegal grows, and now we have a lot of farmers who are trying to attempt to mitigate that and come in and clean it up. And so in the Sequa document, does it take into consideration the improvements of a community that might have been doing a lot of damage, but now we're trying to mitigate that?
Let me take it out of specifics that might be, happening in Trinity County and look at it in a more theoretical way, if I may.
Sure.
If you have evidence that, let's say that, let's go to this San Diego example I had, where a miner had disrupted this creek system and was coming in with a sand and gravel operation. And let's say that 6 or 7 of them had done the same thing. And the city was now looking at an ordinance to allow 10 sand and gravel mining operations. If they said those 10 sand and gravel mining operations would go over those 6 sites and 4 more, then we'd probably say, okay, let's look at the change that we know is going to happen to each of those sites, and we'll look at the environmental difference to that, and maybe there wouldn't be a significant effect on a resource that would otherwise occur if it was pristine ground. So it really depends on the specifics of the circumstance and the predictability of where you are. CEQA is not a one-size-fits-all sort of thing. So, yeah.
I'm just, with the baseline, or the particulars, there are a lot of situations in Trinity counties where there has been disturbance that are being corrected. And I was wondering how the EIR takes that into consideration, and it sounds like it really doesn't.
Well, again, I really do want to avoid
I understand that.
Directly commenting on the EIR that we're currently preparing, because we are currently preparing it. But if there was some provision in place that in the instance somewhere else that all projects where there is damage, the only place we're going to permit is on those areas, or those areas are all going to be improved, and yes, an environmental document would need to consider that. Yeah.
Thank you.
Yeah. Let me just add something to that. One of the challenges we have is under CEQA, not to mention, even though you probably think that we're spending a lot of money on preparing this environmental impact report here, it's a lot of work that goes into this, and we've got a lot of analysis and assumptions. It's very, very difficult to get down to a site-specific level when one's looking at a broad landscape. You try. What we're required to do is look at reasonably foreseeable effects of projects. So we have to come up with a list of assumptions. We have to make sure that we're not violating the very first principle of CEQA, which is to err on the side of protecting the environment. That's in the preamble of CEQA. So we tend to be conservative in our analysis. We don't always get it right, but we do try to consider local, whatever factors we can and cite specific issues and things like that. So, yeah.
Sorry.
Okay.
Any other questions, Commissioner Stewart?
No, actually, we've already asked the questions.
Okay, all right. This is on the process that obviously the elephant in the room is that the EIR will come to both the commission and the board. And we just wanted everyone to get acquainted with what we can and can't do when it comes before us. And I'm sure commissioners, you'll get even more instruction once it does come before you, as will the board. Any other technical questions on what we've heard today before I open it up to the public? So before I open it to the public, again, for those who arrived a little bit later, next week, the 26th, the Planning Commission will hear a workshop on the EIR itself, and I believe it will come then to the board in early October as a workshop on the EIR. Director Hunter, did you want to add some other things before I open it up?
If I could, real quick, we were going to go over Title 18.
Oh, right,
Just
okay.
briefly, and it won't take too long.
Sure, thank you. So hold your questions and then we'll get Title 18.
I have a quick question. It has the day, but it doesn't have the time or the location. Do we have those worked out yet?
Why don't we hear Title 18 and then we'll get your
Okay.
questions and wrap that up.
So quickly, Title 18 is a reference to Title 18 of the county code, and that is the codified procedures that this county follows in implementing CEQA. CEQA requires every agency, what we call lead agency, in this case the county, to have procedures for how to go through the process that our consultants very excellently explain. And so that is set forth in Title 18. The gist of Title 18 is that it's a staff level determination. So much of what you saw today, at least the initial stages, happens at the staff level. And so Gary talked about the Appendix G Checklist. That is something that the staff consultants will go through. They will look at the information that an applicant provides. They will look at other information. They will look at, when I say other information, I mean information in county files, information available from other governmental agencies, and then they will make those determinations. And when they make those determinations, the Title 18 requires them to notify the applicant or the licensed applicant or the permit applicant what staff's determination is, whether there's going to be a negative declaration or whether there will be an EIR, and then once that decision is made, then the appropriate environmental review goes forward. So if the decision is to have an EIR, then staff will work with a consultant to prepare the EIR. If the decision is that a mitigated negative declaration is appropriate, staff will then work to develop the mitigation, and then that will come to the Planning Commission along with whatever entitlement is being requested. So a condition, let's say staff determines that a mitigated negative declaration is appropriate and it's an application for a conditional use permit, then the planning commissioners will hear the conditional use permit application, and then the mitigation will be asked to adopt the mitigated negative declaration. And then if it's an EIR, then the planning commission would initially look at the EIR, and then ultimately the Board of Supervisors, particularly if it's a general plan amendment or a zoning amendment, would make the final determination. But the idea is that the staff is doing all of that preliminary work that our consultants talked about. Staff has a process for determining if exemptions are appropriate, and if they do determine an exemption is appropriate, then they issue the notices. So the general authority of the initial decision-making in our CEQA process is given to our planning director. So ultimately, she makes the decision, is this project exempt? is this project subject to, or does it require a mitigated negative declaration or a regular negative declaration, or does it require an EIR? And then if there's a negative declaration or an EIR, then those come to the planning commissioners and then possibly to the board with the decision, whether it's a general plan amendment, conditional use permit. So that's what Title 18 is all about, and the process that you heard, that's what staff does. Staff spends a lot of time, and it is a time-consuming process to go through. I know we're not talking about cannabis, but obviously that is one type of application that our staff looks at, which is the cannabis licenses. But you also have any number of other applications that go through, and it's a very, very busy office. So I'm happy to answer any questions just about that process if there are any.
Thank you so much, Derek. Director Hunter, do you want to just reiterate your upcoming dates? Because we do have some new people that came in. And I know Supervisor Chadwick had a question.
Yes, thank you for this opportunity. Yeah, the dates that we will be having cannabis cultivation EIR workshops, Thursday, September 26th. This will be a planning commission meeting, a regular planning commission meeting. The meeting will be held in Hayfork. Then on Tuesday, October 1st, will be a Board of Supervisors meeting, and that will of course be held here in this room in Weaverville. The times and dates are not, have not been nailed down yet. We have ideas.
Times and locations.
A location for, well,
You have the date. You said times and date. You have the date, so these are,
sorry.
I just want to clarify. I'm sorry.
yeah. Yes, we have the locations. Hayfork will be at the fairgrounds. The time for the Thursday, September 26th meeting, we do not have that yet. And with the agenda with the board, also to be determined on a time frame with that and how that's going to be worked, but we will have that soon. I definitely get that posted on the planning department website.
And that's a normal planning commission night anyway. Right.
It is.
And that's when we meet.
A normal board meeting, so. Okay.
I feel like there was another part of that question. Okay. Thank you.
Thank you. Okay, questions for our consultants from the public? We'll have this kind of informal. You can sit down or come up, whichever you'd like, since it's a workshop.
Well, I would like to ask the consultants about piecemealing and cumulative impacts. It seems like the course we're headed on ignores those parts of CEQA, because we have an EIR that is being prepared for 10% of the cannabis activity in the county and ignoring the 90%. That's the cumulative impacts. And are you planning to piecemeal, to do a EIR for 50 licenses and then another EIR, piecemealing it on up until you get to the number of licenses that ultimately will be issued in the county? It seems like we're headed in a wrong direction.
So I think those questions can be addressed on the 26th. I'm sorry, Joseph, this is really just a workshop on the CEQA process. So those specific questions, if I'm not mistaken, I'm looking at council, those specific questions to our EIR can be addressed at these upcoming workshops. I do.
General question regarding cumulative impact can be discussed.
Yes.
In general.
In general, we'll look at, we can talk about that, but I can't really go into the weeds, no pun intended, but on the EIR specifically.
How about the October 1st meeting? Are you going to make any decisions on
No,
that? Or are you going to hear?
Those are going to be both workshops on the EIR specifically. But we can address the cumulative impact in general, I believe, today. So do you guys want to address that generally speaking?
So yes, I'm sorry I turned this back the other way, so maybe I'll do this, not to seem rude. But yeah, CEQA requires in EIRs that the cumulative impact analysis look at past historic land use conditions, present conditions, and future conditions, which takes into account more than just the project you're evaluating. So cumulative requires you to look at the totality of that, and some of that may be a localized look of the effect, some of it may be countywide, some of it may be region-wide. An example of that would be impacts in an air basin, which would be beyond just Trinity County. In regards to piecemealing, the rule in Sequa is the EIR and its project description need to address the whole of the project. So anything the project could directly or indirectly implement or do, the EIR needs to capture that in its impact analysis.
Only the program of 500 licenses?
However the project is defined.
I think it was Marie had a question.
So this is a question regarding process. I recently read a really great article regarding the Lotus versus Department of Transportation case from May of 2014 was when it was written. And it was really interesting. In that article it stated, if an environmental protection feature modifies the physical environments of a project as expressed in its site plan or design, we believe it is permissible to include that feature as part of the project description. Therefore, the significance determination will take into account the environmental protection afforded by that feature. Can you speak to whether water board enrollment as a prerequisite to the county and state licensing programs would be appropriate to consider as part of the project description or as a mitigation when analyzing project impacts?
Following the rule that's set out, I'm not going to get specific on the water board question, but I will address Lotus and what it does say. It was a very interesting case. That case, in that case, Caltrans had added a lot of environmental protection measures in its project description to a segment of the highway that went through, I think it was Redwood, State Redwood Park. And what they had done in that was they just added these environmental protection measures and then said, well, we're not going to affect any redwood trees, without going through the analytical steps of whether those environmental protection measures automatically would or would not protect the trees. So what Lotus said is that you can include environmental protection, and effectively what it said was, you can include environmental protection measures in a project, but that doesn't excuse your need to analyze what the impacts are without those measures in place, what the measures then do to reduce the impacts, and then what the residual effects are of having those measures in place. It also had some definitions of what was and was not a mitigation. I don't think that's really relevant to your question, but what it does stand for is when we look at environmental impacts, what we try to do is we try to articulate all the regulations that are in place that are required to be followed. We talk about environmental effects that would occur, and then we try to talk about what these regulatory programs that you're required to follow will do to reduce those effects. And then if there are residual effects that are still significant, then we'll try to come up with mitigation measures that address those residual impacts. So it's kind of a stepwise process. So I hope that answers your question.
Yeah. Richard, I have Commissioner Stewart has a quick follow-up, I think, and then we'll.
It actually was a follow-up about the cumulative impacts. I've been sitting here thinking about it, and what I believe was said was that when you are looking at a program, that you look at past effects, what's going on currently, and then what needs to be done to mitigate. But when you talked about baseline, you said you start with what you have now. That seems contradictory.
Sure. It sure does sound like it, doesn't it? It's kind of a difference in where in the environmental impact report you are. So when we're looking at the effects of a project itself, then we'll look at so there's different sections of an environmental impact report. So one is just the effects of the project. So that is compared to the baseline condition. So there we'll look at the impacts on the baseline. When you look at cumulative effects, you look at the project and you look at past and present and future projects. It's kind of complicated, but you look at all of them in total, and then you put the project on top of that. So what we might say, and let me give you an example of, that looks at air quality as a for instance. A polluted air basin is a damaged air basin. We can all agree. I live in one. And so the project will look at the environmental baseline, which is the air basin. It's polluted, and it'll say, okay, on top of that, the project will generate 10 tons of particulate matter a year, and that's above the threshold of significance, so it's a significant environmental impact. Now, under the cumulative, we'll also look at it and say, yeah, it's a damaged air basin, and there's also these other projects that are proposed in the region that are going to further damage it. So under the cumulative, we'll also say that we'll contribute significantly. It's called a considerable contribution to that impact. That threshold may be actually a little bit lower in the cumulative because all these other projects are just, they're taking up the environmental capacity of that basin to absorb pollution. So we might even look at a smaller increment to cause a significant cumulative effect. But that's really the difference. So that adverse environmental baseline is, under the project, we just put the project right on top of it, and we say, here's the effect of the project on that adverse baseline, if there is an effect on that. In the cumulative, we look at that adverse baseline, we put the project on top of that, and we put other projects in the region that might occur on top of that too. And we say, with all of those together, what's the project's incremental change? You don't look like you're...
No, because you still don't, because he specifically said, Mr. Angel, was it?
Yes.
He specifically said that for the cumulative, you look at what went on before.
Yes.
And so where does that come in?
That is articulated in what's happened to the environment.
And what caused, it's articulated in what's causing the problem
Sure.
right now.
Yeah, and we'll try to,
Okay.
in a damaged environmental condition, the Central Valley is a great laboratory for this. Agriculture has damaged the habitat of the Sacramento Valley, so we'll say that's a past change that has come in to change the conditions.
Yeah, I understand that.
Okay, thanks.
Thank you.
Gary, you might want to stay up there. My question is, if you could speak at length about tiering and educate us a bit more about tiering, please.
Can you give me a specific question, because I can talk all day?
One example might be a project that required, as part of the application, that required prior permitting from other agencies that might already have certified Sequa documents as part of those permits that are required before you even apply for, say, the project in question.
Oh, yeah, sure. So, gosh, a great example of that would be, we just in Sacramento adopted a habitat conservation plan. So there are already plans and programs in place to take care of all of the endangered species in the region, right? There's the Endangered Species Act. So in following the Endangered Species Act, you look at each effect, you go for a take permit, and on an individual basis, you try to mitigate the effects. Oftentimes at a landscape level, you're still damaging the overall habitat, because on a landscape level, you're not, the state program's not equipped to look at the specifics of the habitats and the intermix of those habitats that are being affected in that specific geographic area. So a habitat conservation plan was prepared, and in that habitat conservation plan, it looked at these interactions between the species, the very specific conditions to Sacramento, the groundwater table, how that groundwater table interacts with the different species, and it has broad landscape level programs in place that help to take care of those conditions. So here you have a state program, and then you have a local program. It's also adopted by different state and federal agencies, but that's immaterial to your question. And so it improves upon this state program by looking at the local conditions and kind of picking up those conditions that just can't be evaluated at a statewide level. So I hope that helps.
A little, but more specifically, if a prior permit is required, shouldn't that be, or could that be front-loaded into the front of the document as a project, part of the project description, and not a mitigation measure afterwards?
If there are regulatory programs in place that mitigate an environmental impact, or that partially mitigate an environmental impact, then we will look at those, and we will only try to mitigate for the increment of environmental significant effect that's not taken care of by another program. Happens a lot. Now, a lot depends on what the local environmental thresholds are too. So,
your slide that touched on thresholds of significance was only up for about 2 seconds. I wonder if we, and I've taken one of your classes before, it was great. It's spent a lot of time on that. I know other people have questions, but if there's time toward the end, if we could discuss thresholds of significance and look at that slide, that would be great. I just want to make time for other folks.
Sure, let's go back to the slide real quick. Since we're on it.
Further back.
quite earlier. Keep going about 10 up. A little more. About 3 more up, I think. Gone 2. There you go. That's it. A threshold of oops. Boy, we're still there.
Slide 25.
There you go.
Madam Chair, is this going to be in the back?
Okay. A threshold of significance is an identifiable quantitative, qualitative, or performance level of a particular environmental effect, non-compliance with which means the effect will normally be determined to be significant by the agency, and compliance with which means the effect normally will be determined to be less than significant.
I don't want to get into the cannabis EIR, but can you give some examples of ways to identify thresholds of significance? Especially, it seems like the performance level and the qualitative and the quantitative, if they're already being addressed in a prior certified environmental document, like with another agency, for instance, the Water Board or Fish and Wildlife,
right.
LSA. I guess what I'm hoping for is if you could speak to how thresholds of significance, they can be determined by expert opinions, data, and other ways too. It sounds like performance and qualitative are more subjective, but can you speak a little bit more about determining thresholds of significance, and especially in light of, my understanding is thresholds of significance are best determined early on in a project with an initial study.
When they can be, sure. So, look, having gone through in my career some 500 to 1,000 environmental documents, each circumstance lends itself differently. It's just the way it is. You know, it's, some of the things that Sequa says are really nice and ideal, but in the reality of actually putting together documents, it doesn't always work that way. So let's take a water quality threshold as an example, and I'll just give you an example of a project that we worked on. It was a wastewater treatment plant project that discharged treated effluent into the Sacramento River. There are standards in place. There's water quality standards that were adopted by the State Water Board. There's a permit that says you can't go above these levels in the effluent. So you'd say, okay, that's great. This is the Regional Water Board came up with these standards, and this agency is following them, so there's no significant impact, right? Well, not so fast. In our consultation process, we found that, well, there's these things called endocrine disruptors. There's no standards for them. So we had to look at that as a separate issue because there's just no way to address that. So the local issue that was very important. There were certain fish species that were were sensitive to copper. But copper was not one of the chemicals that was included in the permit. So it's not always cut and dry. The standards that were in that permit weren't sufficient to address the local conditions that we were addressing. We had fights between resource agencies about that. So that's an example. You know, I'm not going to, can't get into any examples here, but I'm just saying that there are differences. We try to address thresholds as early in the process as we can, but sometimes as you're in the process and you learn more about local resources, we don't want to just stand on ceremony and say, well, we said that that was the threshold, but we were wrong. We'd rather get it right. That's what the scoping process is for. That's what the process of going through review of draft EIRs is for. And I'm hoping that all people who do this sort of work aren't in this to be right because we wrote it. We want to be right because we're looking at information. As new information comes to us, we adjust and we try to incorporate that. And sometimes we say, yes, we made an error here, and so we adjust to that. So this is, you know, it's a humbling process to do this. We're dealing with a lot of information as we go through it, and yet we have that overarching obligation to be environmentally protective. So that's our thinking. Oftentimes, we do that, and then a decision-making body says, nice job, and all that. We disagree. Here's why we disagree with that approach that's in your environmental document. And we think there are social and economic and technical reasons why that mitigation is infeasible, so we're going to override it and not adopt it. That happens too. It doesn't hurt our feelings. We just want to try to provide information that is good for decision makers. We don't always get it right though.
Anything else?
I guess I just had a couple quick questions, or at least one question. Oh, really? Are we late? I'm sorry, are we already over time?
Oh, no, I just had the microphone. I wanted to make sure that I had a job, so.
All right, fair enough. I guess what I'm wondering is what happens if during the EIR process that it takes more than the comment period allowed for comments on a draft EIR to produce the data and thus the substantial evidence by experts to refute points made in the EIR. I may have muddled that, but essentially the draft EIR comment period is, let's say, 30 days, and it takes longer to collect data and produce substantial evidence by experts than that time allows for. What happens in those cases?
It's here. That's probably better for me.
Yeah.
So,
With the comment period still being closed, of course,
so the way it works is that if there's a statute, it's Public Resources Code 21177, and it says that the agency must consider all comments that are made prior to the close of the public hearing. So ultimately, if the agency receives a comment before the public hearing is closed, even if that's months after the expiration of the 45-day comment period, it has a duty to address the issue that is raised. The difference is that in the comment, when you submit a written comment during the 45-day period, the agency has to prepare a response to comment, which is a written response. So the only written responses the agency has to provide are to those comments that come within the 45-day period. But if an issue is raised orally at the public hearing before the hearing closes, and the agency doesn't address that, then the agency is sort of in a bind, because if somebody sues the agency and says, you didn't consider this comment that I raised, and the court thinks, you're right, you raised a good comment, and the agency should have addressed it, the court will then find the EIR invalid. So as a practical matter, the agency needs to respond to all relevant substantive comments that come in before the close of the public hearing. So if right now people are worried, there's an EIR process underway, there's a comment period underway, and people are thinking, we need more time to bring in experts and develop our support for our position, just know that you have that time, but you should present that to the agency. So when we have a planning commission hearing, whether it's this county or some other agency, or you have a board of supervisors hearing, ultimately you're going to have to present that by either or both of those hearings.
Okay.
As regards the process in general, how does it work between the agency and the consultant with the delivery of the environmental document? Does the consultant just say, here you go, pleasure doing business, good luck defending this? Or we warranty this against all comers? Or we'll give you an extended warranty for a fee? I'm sure every contract is unique, but how does it generally work?
Given I'm the person who signs those contracts, it might be nice if we could just drop off the document and say, here, good luck, we got it right, but that's not how it works. Under CEQA, actually the board is ultimately responsible for ensuring the adequacy of the document. Doesn't that sound like a burden on them? When we prepare environmental documents, they undergo a lot of back and forth. We do administrative drafts, we do screen check drafts. Our clients review them, they comment on them. The requirement is that the environmental document has to reflect the independent judgment of the lead agency. We're just a vehicle to do that, and so that's what we do. Hope that answers your question.
And in the event of litigation, do you support it, or are they on their own?
Well, look, it all depends on what the contract says. CEQA is a very litigated law. The courts rule in the way they rule. Precedent is set all the time. It's not a we're right, you're wrong kind of thing. We're doing our best. Everybody's doing their best to provide information that the public and the decision makers can use to make a good decision. And that's our obligation, is to do that and to follow the guidelines. But as you've heard today, there's a lot of interpretation. And how many lawsuits are there filed in CEQA? How many precedent-setting cases are there?
It's hard to find a major project that's approved that doesn't get sued.
Yeah, it's just the way of the world, the way that the world has come. Gosh, if we had to defend our documents on our own, it wouldn't be a very good business to be in. To say that. Yeah.
I have another question for Commissioner.
Mr. Cole, did I hear you correctly that oral comments made within the certified comment period must be addressed in the CEQA document, in that, excuse me, the EIR?
Oral comments made to a hearing body
Yes.
will accomplish what in the legal world we call exhaustion. Exhaustion is not, I'm falling over because I'm terribly tired. It's, I've exhausted my effort to present the issue to the agency. It's a legal doctrine that says if you file a CEQA lawsuit, you have to show that you raised your issue to the agency before you filed your lawsuit, and you had to give the agency an opportunity to address your concern. And if they didn't address your concern at all, or they didn't address it adequately, then the court has jurisdiction to consider the argument under a concept called exhaustion. So it gets a little complex, but if somebody wants to have a thorough, thoughtful, written response to their views of an EIR, they should submit a comment to the agency within that 45-day period. If they don't do that, they can still raise issues to the agency. It's just there's no affirmative mandate that the agency has to produce some specific response. But the catch is that if the agency doesn't respond, then that person exhausts their issue. And I will be the CEQA practitioner here who's litigated these cases. There's a concept that we call a late hit, which is in jurisdictions where there are constantly CEQA projects and CEQA lawsuits, what happens is people who want to challenge a project will not comment during the comment period. They will wait until the last hearing in front of the city council or the board of supervisors, and if that hearing is on a Tuesday, they will drop a 15-page single-spaced letter with about 150 pages attached on Monday night. And the hope is that something in there will escape scrutiny by the agency, and then they'll go to the court and say, look, we raised this issue on page 6 at the very bottom in one single sentence, so we exhausted it and they didn't address it. And I will tell you, as someone who has litigated tons of CEQA cases, people get away with that. And so I want to echo what Gary said, which is this is a litigious area, and this is just how the game is played. But obviously that's me, the cynical lawyer. The reality is the reason we have a comment period for thoughtful people who genuinely want their agencies to consider what they have to say is so that you have an opportunity to hear what they have to say. And ultimately, I concur with what Gary said. Ultimately, the EIR is the product of what this county wants it to be. Obviously, it has to meet the legal standards, but our consultant has prepared a project or a product. But ultimately, at the end of the day, if it's a planning commission decision, the planning commission has to independently make its determination. And then if it's a board determination, the board has to independently make its determination.
Please don't step away. I want to follow up. You referred to agency. In this scenario, is the agency the contractors, or is it the county, or is it the planning department? Who are you meaning when you say agency?
So the agency is, well, let's say it's a county project, the agency is the county. And as you all know, there are different levels of decision making within the county. And so there are some more routine applications that are decided at a staff level. So for instance, we have planning director decisions that can be made, and the planning director will have to make a decision as to what level of CEQA analysis. Usually she would have to find the project to be exempt, and then she can issue some type of approval, and then if no one appeals it, then it's approved. Conditional use permits are an example of something that goes before the planning commission. And so the planning commission will make that decision, and then, as I said earlier in my presentation at the beginning, maybe there's a negative declaration that's attached to that. And then there are the legislative changes, and by legislative I mean general plan amendments, and zoning ordinances. So Supervisor Chadwick, that's something you and your colleagues on the board are the ultimate decision makers. So there's one agency, and so when I say agency, any decision that is made under CEQA is considered a county decision, but it may be that a different person or entity within the county makes the decision. So it could be planning director, could be planning commission, or it could be you and your colleagues on the board.
Thank you.
Derek, I have a question for you, a little different, kind of from what they said earlier, and I'm not making sure I heard this correctly. So when the commission and the board ultimately get an EIR given to them, there's going to be some alternative options. How can those bodies address those options? Can they take, well, I like what's happened in alternative 1 and alternative 2. Can we use some of this together to make a recommendation, in essence, to the board?
As with,
and maybe you don't want to talk about here?
Well, I would say it's one of those it depends arguments, and we lawyers are classic at saying yes, it could be yes, it could be no. As a general rule, you would want, as an agency, if you're adopting an EIR, you would want to take one of the alternatives. And so an EIR should analyze any number of alternatives, and generally you would want to pick one of the alternatives. The mixing and matching is something that can be done, but the concern is that you can't get out, if any aspect of that project hasn't been studied. In other words, if the agency says, well, or the Board of Supervisors, well, let's not even pick on, let's pick on city council.
Yeah.
So let's pick on a city council, and they say, well, we don't particularly, we want to go in this direction. We appreciate the EIR. You've shown these particular alternatives, but what about X? And let's say that X really hasn't been addressed in the EIR. We haven't outlined what the impacts are. In that situation, the right legal thing to do would be for the agency to say, we want you to go back and recirculate the EIR to study that particular aspect. We appreciate the work product you've prepared, but we're the elected body and we're looking at it a little differently, and they would send it back. I have seen that happen many times, and not only city councils, but Board of Supervisors. But there might also be a situation where a council looks at something a little differently than the consultant does in the EIR, but the overall impacts have already been studied. And so in that situation, we can work with the findings. You know, ultimately you will adopt a set of findings for any project that you approve. So if you're going to adopt a general plan amendment, let's say you're going to update the land use element of your general plan, you'll need to adopt findings. And in that situation, we would, staff, your county council, your staff would work with, and then consultants, if you have an EIR prepared, would present to you findings, and then you could, in those findings, tailor your specific determination.
And one more question, and you kind of touched upon it with recirculation. We could just send a portion of that to be recirculated as well, correct? We don't have to have the whole thing, but just
Correct.
a piece that somebody thinks needs to be reviewed.
And that's usually what happens.
Yeah.
Usually recirculation isn't, I don't know that, obviously these gentlemen they've prepared so many more products than I've seen, but I've never really truly seen a wholesale recirculation. It's usually, go back and look at this subject or that subject, and it's usually 1 or 2, 3 areas. And I don't know, is that your?
Well, just.
As you were describing this, that very project that I was responding to this gentleman with, the wastewater treatment plant in Sacramento, in the middle of developing response to comments, this was a very controversial project, and the lead agency and several of the people who wanted to litigate got together, and they decided on an alternative that wasn't quite addressed in the environmental impact report. So what did we do? In response to comments, we addressed it. We made sure that the response to comments, we just sent out the entire response to comments package for 30-day review. So it it had the effect of meeting the recirculation requirements that we were looking at. I think it was 30 days. But anyway, we did that. I wanted to make sure that everybody was comfortable with it. Everybody was comfortable with it, everybody was happy, and now $2 billion are being spent on a wastewater treatment plant.
Okay.
There you are.
I think that was helpful. Any other comments, questions? Oh,
Can you talk a little bit more about recirculating the document?
Okay.
You said that they reopened or you circulated a draft with the responses to comments.
So, in that, look, recirculation is, excuse me, the question is, what did we do in this one instance? But recirculation is not well defined in terms of this is what you have to do, other than you have to, I think it's actually a 45-day review period that you have to recirculate for. You have to undergo the same circulation as you did the draft EIR. In the one instance that I'm talking about, we just submitted the response to comments with this additional alternative in it as a recirculated document. So, it's fine.
sure.
One thing to keep in mind is CEQA is all part of the process of your consideration of the project. And oftentimes you'll get an EIR that will make you think, maybe we need to tweak something here. It's part of providing that information and that deliberative back and forth and maybe going, okay, maybe we do need to come up with a different alternative or modify the project. Maybe we need to recirculate, maybe we need to do expanded planning EIR. But that's kind of the beauty of CEQA, is to help you give the information to say, well, that wasn't the expected outcome we thought the EIR would tell us. It's telling us something different. So is there something about our project we need to change to get to where we really want to go? So realize that CEQA is also a tool in that way.
Great, thank you. Anyone else before I come back to Supervisor Chadwick? No?
So this is actually for clarification for the public, Madam Chair. Are the slides going to be available on our agenda?
They'll be, can they be posted, Margaret?
The slides?
Yes. Okay, so they'll just be posted.
So that, as long as it's okay with our contract.
Oh, well, but it's, can we post your slide presentation?
Okay, and the second is for clarification on Director Hunter's workshops. I saw the word cannabis, and so I'm wondering, and I would like it clarified, that the public will be allowed to specifically ask questions of the CEQA with the cannabis.
Yes, that is the purpose of those meetings.
Thank you.
All right, thank you. Oh,
One other question, will those, excuse me,
Director Hunter.
will those questions be answered?
yes.
No guarantee.
It's a valid question.
It is a valid question. When they can be, yes. And there are certain questions I asked that we'll take note of, and the intent is to gather comments from folks based on the key topics that were brought up in the final, the response to comments, the comments we received, and those key issues are going to be the focus, kind of that roadmap for the issues we touch upon in that meeting, because it is a very large document, very complex issue, so that will be the focus. When we can answer questions, we definitely will. But not all questions can be answered, but they'll be taken into account. Much, as Derek explained, that we, things we need to address. We want to know that.
Thank you. Thank you.
All right. Commissioner Stewart, Commissioner Ward, thank you for joining us. And thanks everyone for attending. You will have more input questions on the EIR itself at those workshops. So, all right, I believe we're done. Thank you. Thank you, supervisors.